Short of the whole discussion is as follows. As regards the pipelines which have been drawn, the appellants may approach the relevant district coastal zonal management authority within a period of 1 month from today. The district coastal zonal management authority will consider any application made in regard to the continued use of the pipeline and take it in accordance with law within a further period of 6 weeks from the date of the receipt of the application. In view of the request made by the appellants that they may be permitted to continue to use the pipeline along with the storage facility for a period of 1 year, we would think that the interests of justice do require grant of some time. Appellants are accordingly given a period of 6 months from today to comply with the impugned order of the NGT. This is in regard to the direction to demolish the storage tank. The appellant in the first appeal is given a month's time to pay the compensation ordered if not already paid. As far as the direction to demolish the pipeline, the matter will await the decision to be taken by the District Zonal Management Authority. The appeals are partly allowed. There will be no address clause.
Obliged.
Yeah.
501.
You see, from what transpired yesterday, what Mr. Diwan was telling, there were attempts, earlier bills were placed, but it didn't work through. Today, of course, we have the Attorney General also, along with the Solicitor General. So, what he was saying is, there is many a slip between the cup and the lip. Just because a bill is proposed to be presented before the Parliament, it could go before a committee for deliberations. So in near future, it may not be forthcoming. So that is the anxiety expressed from the other side. And we take it that what Mr. Mehta told yesterday, the same is the stand of the Attorney General.
Yes,
if the Attorney General would apprise us of the timeline within which you reasonably expect that an act is coming into force, then there could be a reason for us to sort of say that, all right, we don't sort of proceed with the hearing, but otherwise, you know, there's an element of uncertainty because you are asking for comments from the public and you are saying that you are proposing to present the bill. Now, what happens? We know legislative process it has its own ways of going away.
That's how the consultation process will add
So that's
strength to the whole deliberations both in Parliament and outside. I suppose, therefore, what is one concern is that when the Parliament is likely to get into this job, will, for any reason, the court will kind of orient a parliamentary debate or a public consultation?
No,
may not.
Because
that's one concern.
The hearing is happening not now.
It
was happening sometime in September, perhaps, when such an assurance was forthcoming. Mr. Mehta was there. But as yet, we are at this stage of
the deep dimensions of a debate like this.
We are not looking into their functioning.
Yeah.
The legislature would have its own way of functioning. Yeah. But as a court, what are we doing?
Your Lordship's concern, my Lord, is, my Lord, I bow down to that, my Lord. My instructions are specific, my Lord. The Parliament session has started from yesterday. It's in 2 phases. The second phase would start from 13th of March. My instructions are that subject to the bill getting approval from the cabinet, it has to be routed through cabinet. It is intended to be presented in the second half of this session. That is between 13th of March to 6th of April. These are my instructions, and I have said so on affidavit also. There, my Lord, we have not said the second half part. We say we intend to introduce, but I took instructions, my Lord, day before. Yesterday also, my Lord, I had a discussion with the Honorable Minister. He said we can't say what the cabinet will do, but subject to that route, we are ready and we would introduce it in the second half of this.
This is a short session, Manoj. There is only 1 week.
This is
So
for
that's
on
why
the budget, Manoj.
Yes, only for the President's address and the budget, Manoj, and thereafter.
Bills would necessarily come in the
next session.
Next leg of this session.
Yes.
It can't be introduced in this session. That's
Mr. Sibal has the experience of the other side as well. except,
No, my lords, your lordship is absolutely
no, so
right.
therefore,
I tell
we
you,
are saying that between the
no,
up and
my lords, the way, even when the bill is introduced, my lords, in the second half of this session, my lords, it may go to the consultative committee or the standing committee. And that takes another 2-3 months. So that is there, my lords. That means it can stand over. Ultimately, it will become law definitely by July. This is my, if it doesn't go to the committee, my lords, it will become law immediately. If it goes, it will become law by July. That's the timeline, honestly, that I can give to your lordship. Nothing more than that.
And we, my lord, can't assure what would happen on the floor of the house.
That's right.
Whether it would be passed, it would be.
No, that
And then I
majorities
thought-
are there. We are all in support of.
No, not it would be. I'm sorry, my lord, my learned
So
friend.
the bill itself,
No, my learned friend took it, my lord, purposefully wrongly. I didn't say it would not pass. It would pass, you know, numerically, but it might be referred, etc.
That's what I said. I said that.
That's all.
That's what it is.
so
And,
from the experienced parliamentarian, we are getting a target of July.
Definitely.
So what Mr. Diwan is saying that, this timeline of next session of the parliament, how far that will have a repercussion, that's something we have to consider.
Whereas my request to your lordships is the following, Whereas even if your lordships were to actually hear the matter, we are not objecting to it. Even if your lordships were to hear the matter, what will happen? By the time the judgment comes, Whereas the bill will have either gone to the standing committee, then whereas your lordship's or judgment or passed, your lordship's judgment will stand in the way, Whereas, of the bill that has already been passed.
It might, the parliament may be benefited of the judicial view on this.
The problem
The
there,
parliament-
I'm sorry to say that the problem there is, I'm sorry.
Where
Normally, we wouldn't override, not normally.
No, I'm
We
saying
would
something
not
else.
override the parliament.
No, Malas, I'm saying something else. The problem there is that the nature of this legislation is such that it is not just an ordinary legislation. It has ramifications on investment. It has ramifications on freedom of speech. It has ramifications on privacy. It has ramifications on not just WhatsApp, because today the target is WhatsApp, but it will impact every other intermediary in the system. And that's why 9 distinguished judges of this court said, in matters of this nature, we should await Parliament to pass a legislation. And I will invite your lordship's attention.
That is a.
That's all that I'm
Of course.
Yes, therefore, mothers, what is going to happen between now and July, assuming that's the last date, it may pass in March itself, but assuming, mothers, it is between now and July, what's mothers? If at all, mothers. It took 6 years in the European Union to pass the bill. 6 years.
Maybe
one more thing.
maybe I was wrong in choice of my word that parliament will be benefited, but
Lord, one more thing.
yes.
Once Parliament passes a law, your lordship does sit in judicial review, and your lordship,
That's right.
Lord, obviously can. But your lordship's judicial review, your lordship's judicial pronouncement being debated in Parliament for acceptance or
That's
rejection
not right.
should always be avoided.
Yes.
Not that. Sometimes not laws are passed overriding any
Lord, the
decree order.
Well, if your lordship renders a judgment earlier, what will happen? It will be debated.
it would be debated, but Lord, and the
Well, I would
purpose
not
is,
insist
Lord,
on
the
that.
purpose possibly, I'm not talking about the litigants, Lord, here.
We are not on all this
Lord,
debate. of
discuss the
parliament
bill and find out the inadequacies of the bill,
Yes.
criticize, etc.
We
It
would
should
go
be avoided,
into,
Lord.
we
Why?
won't go into discussion over the bill.
No, but
the
necessarily,
issues
the
issues
issues
will
are
be-
exactly the same.
And
Issues
the
with it.
irony is,
Privacy, consent, they're all the same.
my Lord, irony is, as I said yesterday, I am supporting the users, namely Mr. Diwan and the, my Lord, the side he represents. If the bill comes into effect, it is the intermediaries who will have to challenge it.
My learned seems to be very sure about that.
Your geographical position is not correct.
No, that's correct.
That's what I said.
We don't know, that's a very good speculation.
Yes.
But quite frankly, Millers, I have not contradicted him even once. I personally know, Millers, that in fact, when the bill comes, it will support our position. That's what I think. Maybe my learned friend
Anyway, there's
hasn't.
nothing to challenge that.
We can't speculate.
But be that as it may. This is our submission, Millers.
May I just make a few points? in the nature of recapitulation, just one or two.
I just want to add one thing before he starts.
You are
I'm for Meta, I'm for the main holding company. I just want to mention that there is no Vishaka situation. There are regulations in place now. Already regulations are there.
We said
There
it
is a grievance
yesterday.
redressal mechanism. There is an officer whom you can complain to. He have not made a single complaint to anybody and they're challenging everything in the air. So it's not as if the people are helpless. This is a complete 2011 regulation with a complaint mechanism, grievance redressal officer. So it's not like Vishaka where the law is crying, it's a complete vacuum or people's human rights are being trampled over.
Only one more addition, Manoj, before
Lordship,
Diwan.
just as we don't discuss sub judice, once it is before the legislature, what will happen is your Lordship judgment is Article 141, binding. Some legislature comes. Now, they should not be that your Lordship holds A plus B is equal to C, and then the Parliament says A plus B is equal to D in advance. That may lead to a slightly awkward position, if I may use a term.
Constitutionally awkward. Another aspect.
Just say one thing. These are discussions or debates in relation where there is no specific complaints we are dealing with. As I said, there is a 2011 regulation. That regulation is holding the field. Maybe adequate, maybe inadequate is one thing. But that's not a ground to strike it out and then do what? The second one is on the anvil. The second one is on the anvil. The first one is not challenged. The statutory regulations are of 2011. They are not under challenge. These are, these are kind of allegations. If this happens, that happens. There's nothing concrete really speaking.
Yes.
So that
One addition, Manoj, one addition.
nothing specific. Unless there is something specific, if it has waited for so much time, another 2 or 3 or 4 months can't really make a difference.
In fact, not the.
And have this clash between the legislature, doing one way, court doing another way, just because 2, 3, 4 months are in the interregnum.
But in fact, the question
matter
that they
of 3, 4
framed,
months.
sorry, sir. But in fact, the question that was framed by them for your lordship's consideration was whether the state should act to bring in a legislation or rules. Now that's what's happened. That's in fact the question framed, which is at page 778 and 7789 of the convenience compilation. That is what they wanted. Now there is a law. Now how can they now go beyond that?
Don't wait for the intermediary.
One have a word in.
Certainly.
Only one addition, Manoj. In one of the matters, Manoj, the regulations are also in question. Now the new regime, which is yet to come, Manoj, takes a different view of the regulations.
Yes.
That
That
is
is
not, I must note the point.
That is also true.
Why don't you voluntarily undertake the intermediaries? What is coming?
They should, Manoj. They should.
Yes.
That's our case, Manoj. They should.
Manoj, yeah, we are not standing in the way, Manoj.
We are saying that you have your own code.
Yes, we are compliant.
Whatever is coming.
Whatever you are doing in other countries,
Yes.
you cannot discriminate India. That's, Manoj, the stand of the.
Manoj, hold on. Manoj, that's what. There are two global regimes.
Yes.
One is US.
One is the US and the rest of the world.
So Europe and rest of the world.
Yes.
That's what I'm saying.
Correct.
Then Europe. So Manoj, they are saying you follow the European regime. We are saying you follow the other regime. Now that's a matter that the law will decide.
What is the proposal?
Manoj, if the,
European regime of the-
no, not the
Indian
Europe.
regime, Manoj, which
not the European
protects
regime.
the privacy and Manoj,
Because
everything.
we have possibly
our-
have maximum number of subscribers.
600 million.
Yes.
600 million, Manoj.
No
Manoj,
intermediary can ignore
the
India.
proposed legislation considers both the European as well as the global
And then
regime.
takes a view.
And then takes a view.
Yeah.
Consider
Therefore,
Europe.
that
Our legislation should be the bellwether.
Yes, absolutely. Because
therefore-
we are serving 600 million people. It has to be. It should be.
Intermediaries, Manoj, cannot ignore Indian users.
Absolutely. No, we are not.
Commercially, they cannot ignore.
We will not. We will not. No
In fact,
question.
on behalf of Twitter, I'm appearing for Twitter minutes in one of the petitions. Our affidavit indicates how the proposed legislation takes care of the grievances. So there's no question of intermediaries necessarily being adversarial to this
Whatever
legislation.
is the proposed legislation,
Lordship, please.
are you complying voluntarily with the requirement.
It's under debate, Malad. How can, this is public discussion.
Care of all this.
No, I can understand the central government's stand that Parliament is insisting over or is going to be insisting over the matter. But why are you kind of?
We are complying with the law. Look, there's a 2011 regulation, we are complying with it. We are complying with it.
That is under challenge.
But no.
In one petition.
In one petition, it's under challenge.
Otherwise, there is no challenge.
Otherwise, no challenge.
And there is no stay.
There is no stay.
Not the regulations are in force, they require a privacy
If
policy.
you
We
still
have that
want
in
to hear
place.
it, Malad, we don't stand in the way, quite frankly.
We are not going to.
Malad, we won't stand in the way still now. We have just put our points of view before your lordship. Beyond this, we will not.
Your lordships can consider, your lordships is the anxiety of the private operators. The
No,
government.
no, no.
What is all this?
There's no anxiety.
Yes, import, your lordship, we have been placed, saying that the 2021 policy, which will not collect large metadata, doesn't give an opt-out option, which they gave in the 2016 policy. Let them give us the opt-out option, to opt out of the fact that they will not share data. They are all out of sharing the data. They want this situation, unregulated situation, to continue, so that they will not market the data. We have filed interim applications.
Does the proposed bill deal with that?
Yes,
Of course.
yes.
Of course.
It does.
By nation, it could be complained.
Malad, in fact, the proposed bill says,
Sorry, Malad, present regulations also
Give you
It deals with that.
it deals with it. Even the present regulations deal with it.
That's what I confess.
They deal with it. Malad, they say, if you do not consent, you can opt out of the system. That's what it says.
Means is what? Just a moment.
Malad,
This will not go anywhere.
This is
Just
what
see the present
Malad,
regulation.
quite frankly, please hear the matter, Malad. I don't want to.
Let us see the regulation.
Please hear the matter, Malad. We are not standing in the way at all. We are suggested, Malad, let's hear the matter.
See the regulation.
But I consciously said, when the bill comes, the intermediaries will challenge it. I said that conscious.
Please look at 72A of the Act. Your lordship will get the answer of the current legislation.
Where is the regulation? Let us just have a.
Regulation
Yes, sort of, how much of time is being taken in all this preliminary round that we don't get a.
This is your affidavit.
Now that Mr. Sibal and Mr. Tata, I both heard them say, let us proceed with the merits, let us proceed.
Yes,
with
if
the
you want to
merits.
proceed, Malad, I have
Said to
we
proceed
have
with
no
the merits.
problem.
Let us proceed with the merits.
On behalf of Brother Ajay, I would like to flag a personal logistical issue. I just did a small little calculation. We have exactly 107 days till May 19th. So 18th of June, Ajay will pick off. Yeah, that's a logistic. It's been to the heart of the problem because when you hear it, it's going to.
Take time.
Not going to take all that much.
It's going to take a lot of time. Lot of time. No. You say the anxiety that is being projected is not from the bar side, it's from the bench side.
We have not projected.
Don't make a comment on that.
We are aware of it, but we have not said anything.
And
It doesn't look nice for a lawyer to say that the bench will not be able. We never said.
your lordship's judgment would be quoted across all jurisdictions. So we will also assist your lordship.
So let's have a look at this preliminary. Let's see the regulation.
Let's see 43A first, Malad.
This is the information technology. What are the?
Yes, the Information Technology Act 2000, Malad.
But see section
Section
43A
43A and then the
that's the
regulation.
power to make regulation and then
All right.
Mr. Sibal will show you the regulation. 43.
43A. First,
Yes, we got it.
This itself came by number.
yes. Let's kindly see 43A was inserted by an amendment act of 2008 and came into effect on 27th of October 2009, where a body corporate possessing, dealing or handling any sensitive personal data or information in a computer resource which it owns, controls or operates is negligent in implementing and maintaining reasonable security practices and procedures and thereby causes wrongful loss or wrongful gain to any person, such body corporate shall be liable to pay damages by way of compensation to the person so affected. For the purposes of this section, body corporate means, your lordships may leave that out. Reasonable security practices and procedures means security practices and procedures designed to protect such information from unauthorized access, damage, use, modification, disclosure, or impairment, or may be specified in an agreement between the parties, as may be specified in any law for the time being in force, and in absence of such agreement or any law, such reasonable security practices and procedures as may be prescribed by the central government in consultation with the professional bodies or associations it may deem fit. Sensitive personal data or information means such personal information as may be prescribed by the central government in consultation with such professional bodies or associates as it may deem fit. And then the penalty provisions. Then kindly come to 72A.
The act.
Yes. Capital 72, capital A. Save as otherwise provided in this act or any other law for the time being in force, any person, including an intermediary, who while providing services under the terms of lawful contract, has secured access to any material containing personal information about another person with the intent to cause or knowing that he is likely to cause wrongful loss or wrong. My lord has that?
Yeah.
Or wrongful gain, discloses without consent of the person concerned or in breach of a lawful contract such material to any other person shall be punished with imprisonment for a term which may extend to 3 years, or with fine which may extend to 5 lakhs, or with both. Now, there is no proceeding pending in any court for violation of this. Now, kindly see 75. And this is amended again in 2000 with effect from introduced in 2008. And it is in effect from 27th of October 2009. And there's no complaint so far from 2009 to 2023.
How is sensitive?
Now kindly, I'm sorry.
How is sensitive personal data?
Well, that's in the rules, in the rules. In the 2011 rules, it's there. But let's kindly now come to, I don't know whether your lordship have the same book at page 225.
Or 187.
Or 187, depending on which book your lordship has. It's the information technology, reasonable security practices and procedures and sensitive personal data or information rules 2011. And to say, that there is no regime in place, this is a Visakha-like situation, is completely wrong.
Very narrow definition.
1 second now, we are not on that. We are not on that.
The definition is
If the national is narrow, then the legislation will take care of it.
The court can't expand.
The court can't
Expand definition.
expand the definition and say that, look, it can only strike it down. Yes.
Mr. Sibal,
Yes.
I'd like to know this architecture of data information gathering. What all information do you have?
In fact, that's
to explain the parameters of the case.
Let us,
Well, this is the whole issue. This is a very complex situation. Your lordships may take it from me. Let me, state a basic fact. No personal message on WhatsApp can never be read by any person, including WhatsApp. Including WhatsApp.
what information would you?
Now, if a person is on WhatsApp and on Facebook, he has to be on both. And he is carrying on activities on Facebook. That information, like any other intermediary, will be known.
You would know how many times one has WhatsApp X or Y.
No. Even that is not. That's also not available. So it's a very, as I said.
So what is available?
We have a proper representation to your lordships for that on the merits of the case. We can give it to your lordships. But these are the issues that ultimately will be dealt with, the issues of privacy, the issues of consent. No personal information, medical information, your sexual orientation.
How do you segregate?
Because nobody can read. Nobody can read.
WhatsApp
can't read. Where's the question of segregation?
So WhatsApp, the entire data
Yes.
is
Not even stored by us.
Stored by you.
Yes, it's stored in the individual phone. Both the person who makes the call, sends a message, and the person who receives it, they have the key. Both have the key. We don't even have the key. That's why, Maharaj, there's been no complaint since 2009, where in 2023.
Take Facebook. What do you access?
Maharaj, like any other intermediary, like Google, like Maharaj.
Like
That's
everything which was
that, Maharaj, even the government platforms the same, Maharaj. It is
what we are saying. Whatever one is looking at,
Yeah.
everything is being stored somewhere. Is that the
no, not Maharaj in WhatsApp messages, no.
not WhatsApp?
Yes.
Talking about.
Well, that's known to everybody. If I am on Facebook and it's an open platform and I'm on Facebook, it will be known to everybody. Maharaj. Supposing, Maharaj, I move from my house somewhere else and I use maps. Maharaj, the Google Maps, Maharaj, they will know from.
My phone reminds me that last month where all I have been.
So if your lordship moves from your house, Maharaj, to a guest, they will know that you have moved, Maharaj. That everybody will know. Maharaj, that's the nature of the. Maharaj, kindly see. This is the nature, the whole. Well, this is a complete revolution that has taken place in the manner that we function. And we have, in Facebook, we have privacy policies, Maharaj, in place. And privacy settings in place. We can switch it off. We can switch it off.
We are still in the process of.
Yeah, but so what I was trying to say to
deciding whether to hear the
what I was trying to say, Maharaj, your lordships may, I want to disabuse your lordships of the impression that whatever we say to each other in terms of messages or otherwise, even our conversations, is known to a third person, not even to WhatsApp. Otherwise, Maharaj, if this were so, immediately you would have got millions of complaints that, look, these messages are being shown to other people from the platform. It is part of our privacy policy itself that you cannot use it. You can't. The question doesn't arise. We have filed affidavit to that effect. Maharaj, what is the information we have? Your EMI.
We have your
Phone number, name, which you give. That's all.
That is at the time of registration.
That's right. So that's the only information we have. It may not also be the correct name. Somebody may give a false name. Whatever name you give, that's the information we will have.
The phone number is
Only the phone number.
Basically, it's phone number.
Basically, it's the phone number. There may be some other, but nothing to do with the content, nothing to do with personal information, nothing at all. And if you see, Maharaj, the rules itself, I will demonstrate to your lordships. Just kindly have a look at that rule.
So let us see the present rules.
Yes.
This draft.
Yes, 2011.
How that protects the right?
Yes, here it is. Well, the title is the Information Technology, Reasonable Security Practices and Procedures and Sensitive Personal Data or Information Rules 2011. My lords have that?
2E.
We'll read these. Act means the Information Technology Act 2000. My lords have that, those rules, all of your lordships?
Yeah.
Biometrics means technologies measure and analyze human body characteristics such as fingerprints, eye retinas, irises, voice patterns, facial patterns, hand measurements, DNA for authentication purposes. Body corporate, leave that out. Cyber incidents means any real or suspected adverse event in relation to, leave that out. Come straight, Maharaj, to personal information, that is I, Maharaj. Section 2, Rule 2I, small I. So rules define personal information means any information that relates to a natural person, which either directly or indirectly, in combination with other information available or likely to be available with the body corporate, is capable of identifying such person. All other words and expressions used and not defined in these rules but defined in this Act shall have meanings respectively assigned to them in the Act. Now, sensitive. So, there's a difference between personal information and sensitive personal information. Sensitive personal data or information of a person means such personal information which consists of information relating to password, financial information such as bank account or credit card or debit card or other payment instrument details, physical, psychological, sociological and mental health condition, sexual orientation, medical records and history, biometric information, any detail relating to the above clauses as provided to body corporate for providing service, and any of the information received under above clauses by body corporate for processing, stored, or processed under lawful contract or otherwise. Well, I just pause here for a minute. Since 2009, there has not been one complaint in India amongst the 600 million users who have said that any of this personal information has been revealed to anybody or is known to anybody. And WhatsApp does not process personal sensitive information, does not process. That's our policy. Then kindly come to Mullat's 5, Rule 5. 4, Mullat, 4. Body corporate to provide policy for privacy and disclosure of information. So we have a privacy policy. That itself is under challenge.
The investigating officer requests you for sharing the information.
Yes.
And are you bound to share?
The court gives an order, we share it. But only whatever we have, because what the content we still don't have. So we can't share that. That applies to WhatsApp.
Both are different aspects. They're sharing or they're bound to share. Both are different aspects.
What sharing or bound to share means what? We are now, Mullah, telling your lordships that we do not access any information. So where's the question of sharing it? So if there is a court order saying whatever information you have, you share, we share.
I don't know whether we'll end up discussing the bill, but just to understand it, if you come to 7 of what you call a clause.
Yeah, that's right.
That's right. That's right. 5-7.
Information.
Yes.
Very important.
Correct.
Can we read that?
Yes, 7. Well, it's body corporate or any person on its behalf shall, prior to the collection of information, including sensitive personal data or information, provide an option to the provider of the information to not to provide the data or information sought to be collected. The provider of information shall at any time, while availing the services or otherwise, also have an option to withdraw its consent given earlier to the body corporate. Such withdrawal of the consent shall be sent in writing to the body corporate. In the case of provider of information not providing or later on withdrawing his consent, the body corporate shall have the option not to provide goods or services for which the said information was sought. So he can walk away.
No. Either.
Correct.
No problem.
Yes.
Latter part of the last part of that clause.
Yes.
It permits.
Yes.
Contract it is entered into with somebody else, irrespective of consent forthcoming.
But that's the privacy policy to which they have already consented. Then only it happens.
No, you come to the extant rule, the provision is there already. It's actually a reproduction of already the existing rules in the form of a parent act.
Yes.
You'll find that as Rule 6 of the 2011 rules.
Yes.
These rules.
Body corporate or any person on his behalf shall permit the providers of information as and when requested to review the information they had provided.
Can you read?
Rule 6.
Next
rule.
No, we are asking you to read the rule, not the, we were actually on the act, the proposed bill.
Well, my lord asked me to look at the rules.
We are asking you, okay, you are reading the rule.
I'm reading the rule only.
Rule 6 you're reading.
Yes.
See 5-7 of the rules.
5-7 of the rules is what I was
Existing.
Existing rule.
In section 7 is what we are pointing out.
All right. Let's go to section 7.
Slightly,
I'll just come there.
Proposed.
That's exactly the point. This is our case, Malad. The proposed bill deals with this issue.
No. See how it deals with it.
But Malad, that's for public discussion. That's for.
All right. What you're saying is, just read the last portion if you don't mind.
Of the proposed.
I was Malad.
See section 7 as it is.
I'll do that. Consent of data principle means any freely.
Are you reading 7?
7, consent. I'm looking at consent.
We are on transfer of information.
Okay, I'll see that.
Please read that.
I'll see that.
It's a transfer of information in the 2011 rules.
No, my lord is asking the act.
Proposed.
My lord is asking the proposed.
You don't know what.
Bill.
7 is consent. Yes.
Here are 7.
Yes.
Yes, I was reading 7.
This.
From
this.
I'll read 7 of this.
It's consent.
Consent. That's consent, Malad. That's consent. I was reading the.
The affidavit is reading. Yes.
What are you reading
All
the rules?
But the lordship reading statutory rules, or are you reading the?
No, the present proposed seven.
So that is consent.
That is consent, Malad.
No.
If your lordship gives me the page number, Malad.
Sorry.
You give me the page number.
Not propose.
The mistake is mine. Actually, I was reading from 2011.
Ah,
That's right. That's what I was
so we
thinking.
thought
Malad.
that.
I was reading that myself.
34.
The book belongs.
He's referring to the proposed one now, which comes at page 34.
34.
Convenience compilation.
Okay, yes, yes.
34, Malad, yes. This is the proposed,
Always
Malad.
the convenience
Seven.
compilation.
Discuss seven.
But by passage of time when we start.
The 7 here deals with consent. That's right.
That's right.
That's why we were saying, Malad, these issues are being dealt with.
But then, which is a provision that deals with transfer of information?
17, transfer of personal data outside India. That's outside India. Now, Malad, that's, yes, 17.
Does it deal with?
17.
Now he's on the rules. What is it? You have to clarify what.
Malad,
Reading the proposed, please. Is now proposed.
17 is transfer of personal data outside India.
What about within India?
Malad, within India, as I said, Malad, that we have all now data under the law has to be kept here. Whatever we have.
If that is so.
Yes.
That rule 6, which is currently governing, will continue to govern. Let's take it that you bring the act, but you don't deal with that situation, dealing with transfer of.
There is no rule.
India. And if you read rule 6, which again I am inviting your attention to.
This says notice, Malad. That's what rule 6 is here, body corporate. This is, you are talking about the 2011 rules.
That's right.
Right.
So that will, if you read that.
I'm reading it. Rule 5, subclause 6 is what my lord is reading. Body corporate or any person on its behalf shall permit the providers of information as and when requested by them to review the information they had provided and ensure that any personal information or sensitive personal data or information found to be inaccurate or deficient shall be corrected or amended. There's no problem.
No, it says the transfer of information may be allowed only if it is necessary for the performance of the.
Oh, your lordship is reading not 5, 7, but 7 itself.
7 itself.
Okay. A body corporate.
For assistance. But your lordships are reading the rules from the point of view of WhatsApp, which is one of the intermediaries. The bill, the existing rules,
Yeah.
etc., deal with large number of
Yes.
intermediaries,
That's right.
with which many of us are not even aware of.
What
So
you're saying
it's
is-
all comprehensible.
What you're saying is, you read 7, which is the provision with which we are dealing with as of today.
7.
What does it really say?
A body corporate or any person on its behalf may transfer sensitive personal data or information, including any information, to any other body corporate or a person in India or located in any other country that ensures the same level of data protection that it adhered to by the body corporate as provided for under these rules.
Next sentence.
The transfer may be allowed only if it is necessary for the performance of the lawful contract between the body corporate or any person on its behalf and provider of information, or where such person has consented to data transfer. Yes, we are following this.
You know, that's really perhaps could be the problem, because if you read the previous provision relating to disclosure of information which is contained in Rule 6,
Yes,
please read that.
yes, body corporate.
Check.
Rule 6,
Disclosure.
disclosure of sensitive personal data or information by body corporate to any third party shall require prior permission from the provider of such information who has provided such information under lawful contract or otherwise, unless such disclosure has been agreed to in the contract between the body corporate and provider of information, or when the disclosure is necessary for compliance of a legal obligation. It is for sensitive. It is only for sensitive information.
What you're saying is,
And we don't process sensitive personal
what
data.
you're saying is,
Yes.
a distinction appears to be made between disclosure of information and
Yeah.
transfer of information.
Yeah.
6 deals with disclosure of information,
Yeah.
requires a consent.
Yes.
When it comes to transfer of information,
Yeah.
now, for example, like you said, Facebook and somebody is on both. You make use of the information for purpose of various.
Not personal information, brother.
This is
Not sensitive personal information. No.
any information.
No, 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 no.
Rule 7 makes it very clear.
No, brother. With respect, it says transfer sensitive personal information.
That's right.
So we don't do it, but we don't keep it.
They're telling you, please read the transfer may be allowed only if it is necessary.
But that is by contract or consent, brother.
Correct. If it is by contract with a third party,
Yeah.
without the consent.
It is with consent. It can't be without consent.
But then what does Rule 7 say? Or.
Either or, brother. Brother, supposing I want to perform an operation, brother, the kidney operation somewhere.
You want to perform your contractual obligation. With
Well,
the
there's a kidney operation that doctor wants to perform, brother.
giving perhaps the wrong example. We are giving an example where you have a pecuniary interest to secure in the sense that you have a financial obligation, then you are providing this information and you're getting consideration.
No, we don't.
Back to the-
We don't, Malaj. Your lordship may take it, record my statement. We don't provide that information to anybody.
What is there? That's your statement.
But Malaj, somebody is challenging it. I'm sorry to intervene.
We are telling you the second clause, Rule 7 is capable of being utilized
Yes, I
to
can-
transfer information without consent.
We are within a, we are in
You
a,
could understand.
we are in a constitution bench, Malaj. If we are in a constitution bench, if any such infraction had taken place, it would be before you. They would have said that this is what has happened. We take consent every time. We don't do it without consent.
The question is not whether you do it without consent or without consent. The question is whether law permits you to do it.
But Malaj, law does permit me as long as I have consent.
No, without consent you can. We are again asking.
But there's a contract then, Malaj, then there's a contract.
So if there is a contract, irrespective of the consent of the data provider, I mean the person whose data you are actually going to transfer, you can transfer it.
But Malaj,
That's the law. We are not.
Because if there is a contract, that means inherent in the contract is the consent, Malaj.
That's be part of, the sort of small print.
That's what I'm saying. It is inherent.
Small print that you will have, that you will actually.
No, Malaj, there is no such thing.
For your lordship, is the nature of the consent. And whether
Malaj, just kindly see 5.1. Malaj, we are now going into the merits. Kindly see 5.1. Let me, Malaj, just point that out. 5.1 says body corporate or any person on its behalf shall obtain consent in writing.
What's your,
Well, may I just point out one thing? But let's do your lordships. If your lordships don't mind. Your lordships asked me the question. Kindly look at 5.1. Yes. I'm sorry, Malaj. I'm sorry.
okay, see, because WhatsApp may be in a different position.
Malaj, they are only interested in WhatsApp. They are not interested in anybody else. This is only against WhatsApp. Malaj.
Maximum user is WhatsApp.
Meta is there.
That's
Meta is
Meta is for Facebook, Malaj. They have not challenged Facebook.
Challenge only.
Only WhatsApp.
Can I
But
give
anyway,
another illustration of how it operates? While maintaining that they must not share. But there are, my lord, for example, forget WhatsApp for the time being to understand, my lord, this rule. But there are several intermediaries. One of them is, say, Google Pay or Paytm. Correct, my lord? We use it. In some corporations or some companies, there is a contract with the company and the employer as a part of their purse, that the company would be permitting you to use your Google Pay up to the extent of, say, 5,000 for the purpose of buying groceries. Now, there would be a contract between Google Pay, that is the intermediary, that company which is reimbursing, and the user who is using the Google Pay up to 5,000. And that company would require that you provide us the information that he has in fact used it for grocery. That's kind of a contract model is contemplated. But without consent of the user, no intermediary should or can transfer, share, or any way disseminate any personal or sensitive data at all.
We support him. It's exactly that. Kindly come to 5-1. We agree.
Say about Rule 7, which we pointed
I
out.
just point out consent, Malas 5. It says so. Without consent, it can't be done.
It says contract.
Kindly see collection of information. Body corporate or person on its behalf shall obtain consent in writing through letter or fax or email from the provider of sensitive personal data or information regarding purpose of usage before collection of such information. So consent is necessary. It's at the heart of the matter.
So your normal privacy policy,
Yes,
which we
yes,
key in,
yes.
do they contain this kind of data sharing?
Yes, 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 very much so.
100.
Very much so.
The three links are clicked.
This is the point I was making, Malaj, and this
Basically,
very,
when somebody has clicked in
Yes.
without reading, because
yes.
Yes.
the print is
No, Malaj,
designed to
there's no
balance
question
the-
without consent, it doesn't have.
But if you download WhatsApp,
yes.
the first thing you have to do is to agree to the privacy policy by clicking. You can read it. It's not like that fine print of the dry cleaner without their old English cases.
How many pages are there?
Hardly.
And
But it's
Malaj,
not that much. You can read it. And it is not small print. You can enlarge it.
The pages.
Malaj,
will be
and this is true of, it is true of every app. It's not just for WhatsApp, Malaj. This is
You
true
have
of
to
every app.
agree.
The manner in which.
You have
this
to agree.
consent is
So,
controlled is an
Malaj,
issue
point
to
is, that is the subject matter of the legislation.
Now, without signing the privacy policy,
Yeah.
can I have access to WhatsApp?
No.
So therefore, my lord,
So essentially, with the user, there's an inbuilt contract
yes.
of sharing of information.
Yes, absolutely. No, what information? Malaj, kindly see. Personal information is not shared. Sensitive personal information is not shared. No way. Because we don't collect it. Messages we can't see, so that's not an issue.
So what do you collect as WhatsApp?
Malaj, this-
Available to you.
as I said, information, phone number, essentially a phone number.
Essentially, who I have contacted.
Yes, exactly. That also we don't know, Malaj.
See, my lord.
Then what do you know?
Only know, Malaj, if somebody, if the enforcement authorities ask about a particular individual, we'll give him 2 or 3 basic things. What is called basic information, basic subscriber information.
That is who is from whose phone it is being.
That's all, that we'll get that. That's all, nothing more than it.
When your lordship
The
examines.
name and the
that
phone.
policy,
So, Maharaj, the point that I'm making to your lordships is, these are issues that will be resolved in the law that is being framed. There's a chapter called consent. There's a whole chapter on consent. There's a separate chapter on consent.
In European Union,
Yes.
also is it implicit that you share this information? 1 minute. Do you have the same contract for European Union?
Maharaj, that's a different regime, Maharaj.
No, we are asking.
No, it's a different contract, Maharaj, a different regime.
And in United States?
Maharaj, that's entirely, Maharaj, same as in India. Same as in India. And the rest of the world, same as in India. Now the government is taking a call, Maharaj, looking at both regimes and deciding what regime or the mixture of those. It must be an Indian, Maharaj, flavor to all this. That's what the explanation is.
No, on the lighter side, it was said that whenever we click I agree on any of these intermediaries button, it is with the same application of mind with which we say I agree to our wives.
I don't know.
You don't have a choice.
careful,
You say I agree.
I mean, I don't know. I don't understand the flavor of that consent, Maharaj.
It is on the lighter side, not on the
Later caveat is not applicable to the earlier one.
And there is no opting out in
I
that.
hope it's not an official stand. My lord.
No. This is not an official.
Maharaj, may I tell your lordships another thing? Forget WhatsApp. In many other platforms, Maharaj, including government of India platforms, there is not even a provision which says I agree.
Yes.
Not a provision which even says ask for agreement. Continued use is deemed consent on government apps.
Yes.
Forget about WhatsApp.
Government apps mean which apps?
My lord, IRCTC.
IRCTC.
The ticket booking.
Yes, everything.
Arogya se.
Arogya.
Then my lord, Beam.
Any-
The payment app.
There is no reference to consent
At all.
So your lordships are now, if your lordships make this kind of law, all of this will be out of business.
They will be out of business.
We will still be in business.
By Parliament.
But all I'm saying is if you enter into this field, Maharaj, then all these issues will be, and that's exactly what the legislation is going to deal with.
Lord, may I put it another way? Kindly ask them what is that personal information which is shared of which they are aggrieved of?
That's all.
We must understand that, we are debating it.
I'd like to put to you something different. Kindly come to the rule defining personal information.
Yes, we'll come to that.
Section 2I.
Yes, I'm coming to that.
I.
Means any information
Correct.
that relates to a natural person, which either directly or indirectly, in combination with other information, available or likely to be available with the body corporate, is capable of identifying such person.
Now you read the specific definition of sensitive personal data or information in 3.
In 3, physical,
No, sensitive personal data or
yes,
information.
yes, sensitive personal data or information.
Kindly read that.
Yes, sensitive personal data or information of a person means such personal information which consists of information relating to password.
Password.
Yes. Financial information such as bank account or credit card or debit card or other payment instrument details.
Physical.
Then physical, physiological and mental health condition, sexual orientation, medical records and history, biometric information, any detail relating to the above clauses that's provided to body corporate for providing service,
Correct.
and any of the information received under above clauses by body corporate for processing, stored or processed under lawful contract or otherwise.
Can we maintain a distinction between personal
And
information-
sensitive personal, correct?
Now, what is the subject matter of Rule 6? Now you will see.
Yes. Only sensitive, Malak.
Only sensitive.
Yes,
Equally 7.
yes.
That also deals with
Only sensitive.
personal data.
Yes, yes.
So is there any prohibition from
Well,
your
seven say-
Five.
personal information?
Yes, 5, Malak, 5.
That is it.
Yes, 5, that's what I was
That's right.
going to along. The body corporate or any person in its behalf shall obtain consent in writing through letter or fax or email from the provider of the sensitive personal data or information regarding purpose of usage before collection of
That is
such
an
information.
expression which is defined, that's the subject matter of Rule 3.
Malak, now
That is not
C7.
the same as personal
No. 7 also talks of any other information.
Let us see.
Yes, C7.
So 5, 6.
7, you losses me C7.
Yeah.
A body corporate or any person in its behalf may transfer sensitive personal data or information, including any information that includes personal information. So it is covered, and I can't collect it till I get consent.
So what about disclosure of information under Rule 6?
Disclosure to whom, Malak? It's only under a contract or consent after consent.
You know what you're saying.
Malak, it says pursuant to contract or consent.
See, there's a distinction between, as you saw, between personal information and sensitive.
And correct.
Number one. The Rule 6 only deals with personal, disclose sensitive personal data or information.
Yes,
It doesn't deal with personal information.
yes.
So if you disclose information as distinct from transferring information under Rule 7,
Yes.
will it be hit by the embargo in Rule 6?
No.
So then
No.
what is the guarantee that you will not disclose?
I don't
I don't collect such, I don't collect that information. How will I disclose it?
It's personal information.
I don't collect it unless without personal with consent.
Supposing
Otherwise, I don't collect.
Supposing I send a WhatsApp, which tends to indicate my musical inclination, that I am interested in a particular, I am listening to a particular singer all the time. Correct?
Correct.
So this information can be made available to somebody who would be
No.
selling that particular.
No.
What you're saying?
WhatsApp doesn't collect it.
Rule 6 doesn't prevent you from dealing with it. For the reason that Rule 6 has its subject matter only what is contained in Rule 3, which is personal and sensitive information, not personal information.
No, it says personal, Wallace.
Because it
says
sensitive personal data or information
No.
is confined. It is a subset of information.
Just read, Wallace. It says personal information.
It is sensitive and personal. For example, they have
Providing such
information.
or information. It says so. 6, Wallace. 6. It says sensitive personal or information.
It says the disclosure of sensitive personal data
Or information.
that is exactly what you now come back to Rule 3.
It doesn't.
That relates to medical. This.
It doesn't say or, Malaj. Rule 3 doesn't say or. It says sensitive data or information.
So that is defined as exhaustively as contained in these, all these.
Yeah.
But what you're saying is personal information is the largest set.
Yes.
The sensitive information is a
It's,
small
I agree.
subset within it.
Yes, yes.
What is contained outside of the smaller set and part of the larger set cannot be made the subject matter of the prohibition in Rule 6 is all that we are saying. We don't know whether what we said. Yeah. I'm not particularly tech savvy, except that I can operate it.
Disclosure of sensitive personal data or information by a body corporate
That is taken
shall
out of
require
Rule 3.
permission.
That is the Rule 3.
Yeah.
That is part of Rule 3.
Yeah.
That is distinct from personal information. See, data and information are two different things.
Well, personal data and information are two different things. Your Lordship is right, precisely what I'm saying, Mulad. And Mulad, we have to take, at the time of collection, we have to take
Kindly
consent.
come to Rule 3, if you don't mind.
Yes,
Sensitive personal data or information.
yes,
It is defined as meaning A, B, C, D.
yes, yes.
Like, then very sensitive, like medical condition.
Yes, with that question.
Or your, financial information.
Yeah, that's right.
There might be personal information within the meaning of Section 2, subsection I,
That's correct.
which may actually be the subject matter of my right to privacy.
Read 11 formulas. 5. Kindly see Rule 4. Kindly see Rule 4.
Rule 4.
Yes. The body corporate or any person who on behalf of body corporate collects, receives, possesses, stores, deals or handles information. I'm sorry. Was you had that?
Yes, yes.
The body corporate or any person who on behalf of body corporate collects, receives, possesses, stores, deals or handles information of provider of information shall provide a privacy policy.
Correct.
For handling or dealing in personal information, including sensitive personal data or information,
Yes.
and ensure that the same are available for view for such providers by such providers of information who has provided such information under lawful contract.
That's it.
Such policy shall be published on the website of the body corporate or any person on its behalf and shall provide for item 4, disclosure of information, including sensitive personal data or information as provided in Rule 6.
Therefore, it is included.
Therefore, it is included. It is included.
Disclosure is included.
Disclosure is included, Malad.
Everything.
And everything, Malad. Purpose, disclosure, clear and easily accessible statements of practices, type of personal or sensitive personal data or information collected under Rule 3, purpose of collection and usage of such information, disclosure of information including sensitive personal data or information as provided in Rule 6. Everything is covered. And then come to 5.3, Malad. While collecting information directly from the person concerned, the body corporate or any person on its behalf shall take such steps as are in the circumstances reasonable to ensure that the person concerned is having the knowledge of the fact that the information is being collected, purpose for which the information is being collected, the intended recipients of the information, and a name and address of the agency that is collecting the information and the agency that will retain information. I have to disclose it.
So your privacy policy must be disclosed.
Yes. No. That I have to, information has to be disclosed. What I am collecting has to be disclosed.
In the privacy.
In the privacy policy. Exactly what we have done.
Simple.
So the point that I'm sorry.
One thing is missing. If you come to this paper book given to us,
Yeah.
page 5,
That paper book.
let us go to the definition clause.
Mighty affidavit.
Mighty affidavit. I don't know what your lordship.
2011,
2011 rules given to us in this compilation.
I don't have it, Mother.
I think
That affidavit of
the government, Mr. Shah has provided to us.
Okay. Page 1.
Page, if your lordship gives me the page.
current affidavit.
This one, that affidavit.
Okay. Yes.
page 5 there.
Page 5. I'll just see page 5.
Come to
Yes.
this 2F is the information, correct?
2F information means information as defined in clause Roman small 5 of 1 of section 2.
Now come to personal information, I.
Personal information means any information that relates to a natural person, which either directly or indirectly in combination with available or likely to be available to the body is capable of identifying such.
Now we come to 3, sensitive personal data or information.
Yes, that's a subset of information, correct?
Now if you come to 7,
7. Yes,
we talk about sensitive personal data or information.
yes.
That is in terms of 3.
No, that's
Including-
transfer of information. That's
including any information.
Your lordship is reading 5 or 7?
7, page 9.
Page 9. Yes, yes. Transfer of information.
Sensitive personal data or information.
Yes,
Including any information.
yes.
Now our question to you is this including any information? Including any information?
Yes.
Covers
Personal information.
from where you get it?
Personal information.
From where you get it?
Because the information.
Because the information before I collect, Mother, section 5 says, when I collect the information, it can be both personal and other information. And I have to now seek his consent for that. That's 5.1, Rule 5. It says so.
Definition of
Definition, Mother, of information includes data, message, text, images, sound, voice, codes, computer programs, software, databases, microfilm or computer generated microfilm. It's all there, Mother.
information, then personal information.
Well, it's first information, then personal information, then sensitive personal information.
So
And all mothers which
and the results.
correct.
Majority are concerned with personal information, not with sensitive.
Correct. So mothers, personal information, as I have said under 5.1, restriction is higher, mothers, therefore I need consent. And that 5.1 says so. Collection of information, 5.1 says. Well, that's the point that I'm making.
Says disclosure.
And then we have to disclose it.
Doesn't deal with it, because you're not right. You read the schema 4, 5, 6, you find that what 4 contemplates is the publication of the privacy policy.
Yes.
That should be made available, what you're going to do with it.
It is available, Mother.
It's available, no
Yes.
different.
Yes.
When it comes to 6, it is only dealing with disclosure of sensitive personal data or information by the body corporate.
Yes.
It does not deal with personal information.
Correct.
It's very clear.
6 deals with personal information.
It deals with sensitive personal data.
Correct. So, or information means.
No, that is because it is covered by rule 3.
Okay.
Rule 3, you have to read it together.
Yes.
It says sensitive.
But 5.3 covers it, Mother. Even 5.3 covers it.
5.3.
While collecting information directly from the person concerned. This is information, but it's not sensitive personal information.
No.
While collecting.
Kindly read again.
While collecting information directly from the person concerned, the body corporate or any person on its behalf shall take such steps as are in the circumstances reasonable to ensure that the person concerned is having the knowledge of the fact that the information is being collected, purpose for which the information is being collected.
If you read 5.3 in isolation, you will not get the correct picture. You have to read 5.1.
I'm reading it. Body corporate of any person or a body corporate or any person in its behalf shall obtain consent in writing through letter of fax or email from the provider of the sensitive personal data or information.
That's again relatable to rule.
Mulaz, or information relates. Mulaz, kindly.
Personal information.
Mulaz, I don't think I've been able to explain myself. Information is defined separately under the Act.
That's right. That's right.
Information, Mulaz, is the genus.
That's right.
Right? Personal information and sensitive personal information are species.
Sensitive
So when
personal data or information.
correct is species. Now, when the word information is used in 5.1, it is in the context of the definition of information. It is not sensitive. Read 43A now.
Yeah, kindly bear with me if I'll just read it out for you. Body corporate, I'm reading out rule 5. Body corporate or any person on his behalf shall obtain consent in writing through letter, etc., from the provider of sensitive personal data or information. Just for a moment, pause and go back to rule 3.
Yes.
That says sensitive personal data or information.
Yes.
Correct?
Yes.
Now, wherever they wanted to refer to both the sensitive personal data or information and personal information,
Yes.
they've done that. An instance in point is rule 4.
Yes.
Correct?
Yes.
When it comes to collection of information with the meaning of rule 5, though
Yes.
it is as usual, the subtitle is misleading, it says information, it is limited only to sensitive personal data or information in 5.1. Now, thereafter, whatever is mentioned, it really is follow upon what is mentioned in 5.1. And then when you come to therefore 5.3, When collecting information directly, it cannot be understood as meaning, referring to something not there in the.
Let's see, read the parent section 43A, Malad, that gives your lordship the.
Exactly, that is the point.
That's the point. Just read 43A, Malad. It talks of information.
What they, because it's a bonded legislation. What they have done is, they have, very carefully, they have made a distinction between sensitive personal data or information and personal information. That you saw disclosure, that being a subset of the latter. And they have confined the use of sensitive personal data in Rule 5, in Rule 6 and Rule 7 only to sensitive personal data or information. In other words,
No, Malad, with respect.
information which is the largest set, which is perhaps considered to be less harmful from the point of view of the right of privacy.
Yeah. No, with respect, no, Malad, and that's not how we have viewed it as WhatsApp, and that's not how we use it.
Yes, so now the petitioner is also.
No, Malad, no, that's not how we have interpreted it, and we are including that and that.
Are we sort of canvassing for a.
Malad, kindly look at 72 now.
Are we saying something which is contrary to what they have?
Malad, let me just.
They will not support us on that.
Do you have?
Malad, just look at 72 first. Look at 72A first. Just 1 second.
72A.
72A.
Section.
Yes, section.
72A.
Yes.
Yeah.
Now it says punishment for disclosure of information, not personal sensitive information. Right? Save as otherwise provided in this act or any other law for the time being enforced, any person, including any intermediary, who, with me includes us, while providing services under the terms of a lawful contract, has secured access to any material containing personal information, not sensitive,
That's right.
about any person, with the intent or cause to cause or knowing that he is likely to cause wrongful loss or wrongful gain, discloses without the consent of the person concerned or in breach of a lawful contract. Yes, correct. Or such material to any other person shall be punished with imprisonment for a term of 3 years. So it covers.
Therefore, how it works would perhaps be, my understanding may be wrong. When you sign up in WhatsApp, like you said, there's this thing, I just but not the formal thing.
Yes.
So I agree to all the terms.
Yes.
One of the terms would be that I would have no problem in my personal information being made available in term pursuance of a contract which WhatsApp has with some other corporate body.
Yes.
Correct.
I have to have a contract with the user, but be that as it may. Let's sort of leave that out. But have to have a contract with the user, there's not some other body.
That's right.
I can't with some other body have a contract and give his information to that body. That can't be.
What they had. Precisely what they had.
What's the point of laughing? We are trying to go into the issue and we will argue it fully as and when the matter starts. That's not an issue. We will show to you. Whereas what I'm trying to tell your lordships is, where are we going?
Take my, for example, my political views. Giving an example.
WhatsApp doesn't look at it even.
No. I'm not saying that you look at it. We are not attributing anything against you. We are just having this.
Well, the whole litigation is against me, brother.
My political views. The political views are not treated as sensitive personal data or information.
Well, I will not be acting for WhatsApp unless they know my political views. I will not be here.
But we are only pointing out.
No, it's a lighter vein.
That's right. Absolutely right. What you're trying to point out is different categories of sensitive personal data or information you find in Rule 3. You don't perhaps find your political alignment as one of the sensitive.
That's personal information, not sensitive personal information. Yes. You're right.
So that cannot be the subject matter of the prohibition contained in Rule 6 or Rule 7.
72A. Yes.
But 72A, yes.
72A is different.
But that's the Marin statute.
There we are going to tell you, as we understand, it is either consent or subject matter of agreement.
Contract, yes.
Contract.
Yes.
So all of it boils down to the smallest of print, which we don't have now in this, because it's an electronic kind of thing, online. So you don't just see it.
It's a more
substance of it, that all this information, which is personal information, not sensitive information, it can be passed on to somebody who would be interested in knowing if for commercial purposes, for their political purposes, it can be used. We are just contemplating that it's possible.
Correct. Malas, the problem with that is, if that is the law, Malas, that there may be a small print, or you may not have understood it, or some people are uneducated, they don't read it. If that's the case, Malas, all intermediaries must stop business in India. And Government of India, all apps in Government of India must stop. That's the consequence.
Sensitive personal information.
Malas, in fact, they carry sensitive personal information.
My views about a particular
Including password.
My views about a particular politician. I'll give an example.
Yeah.
My views about a particular politician.
Yes.
Now, if the views are, sort of gathered by you and passed on to somebody else, you may take a choice to feel that person as a candidate. You may say that it's better not put up that man as a candidate.
Well, all I can say is this doesn't apply to WhatsApp. It may apply to other intermediaries, doesn't apply to WhatsApp.
Only one.
That's all I can say.
These are 2011 rules.
If you go in
Filers, it may not disown the responsibility.
May I add one word, Malak, to this? I'm for Google, Malak, not WhatsApp. This is a question which fell
You
from
are a repository of all information.
Yes, Malak. And therefore, Malak, I'll answer this. What troubled my Lord Mr. Joseph is this. That let's say Sajjan Puvaya, my information, Malak, which is not personal sensitive data, SPDI, sensitive personal data or information is one basket. Now, my medical condition is SPDI.
Absolutely.
Therefore, SPDI is covered under my Lord 6 and 7. Etc.
Absolutely.
There is no problem.
No problem.
Now, let us look at my political views, which is not SPDI. So, the information in SPDI is not political views.
Absolutely.
That is, my Lord, simply personal information or PI. PI, my Lord, is covered under 5.3 because 5.3 is not a subset of 5.1. Kindly see 5.1 for a minute, my Lord. 5.1, my Lord, deals with only SPDI. Whereas 5.3, my Lords, deals with any information that I collect.
That I mentioned.
And therefore, my Lords, that information in 5.3 is a larger set, for example.
Assuming we are not inclined to accept it.
Yes.
Just for the sake of argument.
Hypothetically, my Lords, that's not correct.
Hypothetically. Would they then make out a case for our hearing this matter?
No, my Lords, the answer is no. Because even hypothetically, my Lords, if your Lordships were to say that no, 5.3 does not cover, I am, my Lords, under 4 required to give a privacy policy. That privacy policy must show who is the intended recipient of the information. And if my friend does not want it, he did not subscribe to it.
All right. So therefore, now the sort of, I'm not using the word the cat is out of the bag, but with reference to 73A,
please.
The
72
is linked with, the presence or absence of a contract.
Therefore, my Lords, when I'm giving the private
consent, in other words, irrespective of consent, what you're going to say is that since we have already got a contract with you, which permits you to actually, divulge information, which is personal information, PI as you put it, you are out of the set of obligations which would apply in respect of that PV, whatever it is.
SPDI. Malak, may I watch that? I want this path one step, Malak, just one more step.
Malak.
I'm not on Malak's whether WhatsApp, Google, etc. Now, academically, Malak, one step forward is this.
Yeah.
If the state is providing essential service for which information is being collected, the citizen or the recipient of that service has no option but to, my Lords, access that particular portal and get that information.
Oh,
now,
if state wants, you will have to disclose.
Yes. Now, my Lords, let's look at
the point is the storage itself.
Yes, my Lords.
Because state will want it, then you have a storage of this information.
Yes, my Lords.
And in some kind of filing.
Please.
In the cloud or wherever.
Please.
So how you profile each person, each subscriber. Then what is he looking at in Wikipedia? What kind of song is he listening to? What kind of things he is buying through Amazon? So you are coalescing all this information and helping profiling a person on some unknown category.
See, initially, WhatsApp, as far as I know,
advertisement
was in fact charging for the service.
Yes, briefly.
Thereafter,
we don't charge for the service.
You don't charge.
We don't charge.
Initially,
No, we don't.
Initially they were.
India never charged.
Yes.
Once in India, we never charged.
No, I'm saying world over. We are talking about India alone.
World.
So after they change the policy, so obviously there is a business consideration. Obviously nobody is a
There must be, Madam.
They are not doing it for.
Mothers, I hope, Mothers, there's nothing wrong with that, Mothers, to have a business consideration.
Doing charity, but
Yeah.
nothing wrong, but it's not exactly charity.
It cannot be, Mothers, it cannot
Exactly.
be. Cannot be.
So they are making, there is a sort of hidden cost that you are going to reach.
Mothers, who is getting the benefit of that cost? Mothers, the consumer. Mothers, I give you a lot of an example. I give you a lot, make my trip, Mothers. If I give an example, make my trip, Mothers, and make my trip, I say I've been to Australia 5 times. That information is known to make my trip, Mothers. Make my trip, Mothers, is now advertising. Is advertising. Mothers, when it advertises, it can use that information to give me that, look, in the next 6 months or next 1 year, there's a discount of 50% on that trip. Now, what
It has got both good and bad. Yeah,
No, but I'm just saying, this is the way the world is working now.
You're right. I mean, that's good and bad is there.
Yeah.
I mean, WhatsApp.
So they'll take care of the bad and we'll take care of the good, Mothers.
We actually enjoy life. There's no doubt about it.
Mothers, you get a personalized experience. You get a personalized experience. It is not used for against the individual. It is to enhance his experience.
That is Einstein's theory of relativity is applicable to that personalized experience. It's relative.
No, but the individual, Mothers, if he wants a,
What you meant to say.
if he doesn't want, he can stop it, Mothers.
What you meant to say was when you say personalized.
Mothers, may I?
Exactly personalized.
All right, Mothers, let me put it this way. If he doesn't want any information to be used, he can only be on WhatsApp and need not be on Facebook. Nothing will be used. He'll not get any ad also. But what he wants is, he wants to be on Facebook. He wants to be on WhatsApp. He wants the advantage. And then he tells you that you don't give me advertisements. How can that be? Well, please appreciate. If he doesn't want any of this, he can be on WhatsApp. He'll be fully protected.
This dichotomy.
Whereas I am only on WhatsApp, I'm not on Facebook. I never get an
Right, let us record that statement of Mr. Sibal right away, please. That if you are on WhatsApp
Yes.
and you are not on Facebook,
Yes.
no information from WhatsApp will be shared.
No advertisement will.
Please allow him to record. Please
Yes,
record
please
that
record it.
statement.
Record
Please
it.
record that statement here and now. First and foremost.
No advertisement will
Large
come.
number of
One-
items.
Hold on. Please record
No
my.
information,
One
my
second,
learned
please,
friend
please,
says,
please.
will be shared by WhatsApp with Facebook. Please
Please
record
allow-
that.
record-
And that solves a large number of my problems.
All right, very good. Now, let us record my statement that no, if I am on WhatsApp
That
alone,
in closing this.
No, well, it might have done in a
Well, let's-
benefit.
please record my statement that if I am on WhatsApp, I will not get any advertisement on WhatsApp.
No, that's not the statement. What-
That's what-
information.
If I,
So Mr. Diwan wants that if in the event I am on
both on
WhatsApp,
Facebook,
I am not on Facebook.
yes,
That is.
you will not get advertisement.
Either way,
No information from WhatsApp would be shared with Facebook.
Yes.
either way, if I'm on WhatsApp,
Well, if you,
whether I'm on Facebook or not, you're not going to, that's how I understood the statement, that we don't share and we will continue.
well,
That's
God
not the
asked
statement,
me,
there's no problem now.
I was taking the example of make my trip.
At some point, we must be allowed to also.
Let us not make my trip. What Mr. Sibal has been submitting so far, as we have understood, you may correct us, that if a person is only on WhatsApp
Yes.
and is also not a user of Facebook,
Yes,
then the data that is available with WhatsApp, which they don't use,
yes.
they are not going to share it with Facebook. This is what you are saying. Don't go into the sponsors and advertisements, etc. And that is what Mr. Diwan is now trying to tell us,
Yeah.
that if this be the stand of the client that Mr. Sibal is representing, let it be recorded. Then a large amount of anxiety that they have, that would be assuaged.
Problem there is, Maharaj, that sometimes we need to share the phone number depending on if
No,
there is some violation of any law. But no, we have to share that. That's part of our policy.
Violation of law, state agency asking for it, that's another.
That's all.
Maharaj, if you do some wrong practice, we'll block you from Facebook.
No, those are exceptions.
But that's all that is.
What is your general?
Those are the only things that are there, Maharaj.
Is your general policy, as we have understood, and as you have stated before us,
Yes.
that if somebody who is on WhatsApp
Yes.
and is not on Facebook,
Won't get
then
advertisement.
the data that is available with WhatsApp will not be shared with Facebook. Is that what your category?
That data is of no use to us, Manoj.
No, that's not.
Lord, we'll have to be very clear what we mean by data, what we mean by
Exactly.
That's the most important.
Right,
The phone number.
Yes.
Which is what I seek to at some point explain.
No, you may explain it, but the phone number will be known.
The basics.
Basic subscriber information is what we call it, is known. That's all.
Lord, I'll give example. I'm not on, personally, I'm only on WhatsApp. I'm not on any social
Same
media.
with me.
Only on WhatsApp. Now, what does Facebook know about me?
Nothing.
Except the BSI. I'm not on Facebook at all. I'm not on Instagram. I'm not on any media.
I am also personally only on WhatsApp. I have nothing to do with Facebook. I never get any advertisement. But in answering Justice Roy's question, there is one exception. Suppose I am on WhatsApp only, me or Datar. But Lord, suppose on my phone, there is some child pornography video shared on WhatsApp. It's possible. Lord, the moment that happens, WhatsApp, Lord, in its security, and it is a complaint, WhatsApp security concerns will pick it up. It will first, Lord, disconnect his WhatsApp also. He'll be chucked out of the system if it is found. And that fact that this man's or this phone number was indulging on this in WhatsApp will be sent to Facebook because the owner is the same. So that if after 2 months I want to join Facebook, I will be prohibited from joining. So that's the only security related
That's what I
issue.
said.
I did a case of a person whose WhatsApp account was closed by them, by WhatsApp.
How do you know whether child pornography?
Report. There's a reporting mechanism.
By a complaint.
Reporting
By a
mechanism.
complaint.
Yes.
Because WhatsApp can't read me otherwise.
That's right. The person, Manoj, will report it to the authority. The person who is seeing the child pornography. And then the action will take place.
It would be on the basis of a third party.
Yes.
Not us. We can't see anything.
There is an inbuilt report mechanism also.
As the Supreme Court.
The Supreme Court directed us
India.
that you have said. So if this kind of thing happens, I have done an actual case where a man said, Milord, that he has never done it. His phone was utilized to send, Milord, a child pornographic video from A phone to B phone. The moment that happened, it was picked up or there was a complaint, that person's WhatsApp account was closed forever. So he went to a court and said, now why should it be closed, etc. Then it was found this happened. So that's the only security thing, Milord. Otherwise, WhatsApp can't read, WhatsApp can't do anything. And since for both of us, we are not on Facebook, we don't get any advice.
That is an exception theory.
But
That's what I was saying.
That is what we were saying.
That's all.
If that is an exception theory,
Yes.
then what is the difficulty? That barring contingencies such as this,
Yes.
we don't share it. That is what,
Yes.
that is what the other side's anxiety is. And should you not be saying upfront that this is our policy? You have said so.
Yes, we've said so.
Not that you have not
Without
said.
great respect what Mr. Sibal was saying. Take that example. Today WhatsApp is free.
Well, what they want is they want the free service and they don't want
Please note that WhatsApp is free today. Everything, there is no free lunch in this world. Everybody has to pay something for something. WhatsApp is free today. So there is a business model in which, if a phone number is shared with Facebook and then Make My Trip, is used, then that advertisement of Make My Trip will pop up on that Facebook account.
Not on WhatsApp.
Not on WhatsApp. Suppose, let me give an example.
It's only kirana shops.
Suppose, you are on Facebook, you are looking at, let's say, a particular level of cars. Suppose you're looking at a particular level of cars. So I'm looking at cars which are 50 lakhs and above.
That is only for you people, not for us.
So, let's take an example, not 50 lakhs or 10 lakhs. If I'm looking at a 10 lakh car, you have a choice. So you have a choice of Maruti, Hyundai, etc., etc.
That's not 10 lakhs. 10 lakhs. Well, my lieutenant has no idea of the pricing mechanism.
Some Maruti, I'm sure some Maruti is 10 lakhs. So, those advertisements, knowing your propensity to look at that level, will pop up. You're looking at Maruti for 10 lakhs. It will say, see also Hyundai. See also this. That's what will happen. And then Then some, Google, for example. There is a model with Google. Every time that advertisement pops up and the person clicks on the advertisement only to see, not to buy, Google, will get 1 rupee. Google will get 1 rupee from Maruti because that man has clicked to see whether he has bought or not is not relevant. And that happens across the world. How does Google make money? All this is free.
On hits.
All this is free. You download WhatsApp.
YouTube also the same.
YouTube, all this is happening in the world. Huge investments are there. It is not meant to be given free for everything at all times. So therefore, there is some business model. That's why this advertisement of Make My Trip. So if you are doing Make My Trip, say you are booking Air India. So an advertisement pop up, see related. You press that, it will say BA, it will say Virgin, it will say this, it will say that. You look at Make My Trip.
Rohtaki is always talking about this Make My Trip. You're making use of it. It's very clear.
I have done some cases for them, They have been damned in the competition commission. 500 to 300 crores fine was imposed on them. So if you see Make My Trip, there are 5 other similar holiday trip, this trip, that trip. That's what happens. So it's not as if that some sensitive. There are cases of sexual orientations, right? They are never shared. So if somebody is and now the point is, you want to be within the app, you want to utilize the app also, and say now you tune it the way I want you to tune it. They don't take the app. These
That's
are
what the
private.
rule also says, Mother.
So, no, one more thing, please note. These are private companies. These are private companies. They are not state. They are private companies across the world. You want to use it in this form with our explanation that we are not sharing any personal sensitive information. Otherwise, don't use it.
Options are there.
The problem is, Malad, there is what is called
There
a
is
business
Telegram.
messaging service. There's a business messaging service. If you are both on WhatsApp and Facebook, then this happens of Make My Trip, Alan, if it is talking.
Yeah.
Not otherwise.
It doesn't happen.
So let's,
These are, these are also issues that can you insist that I must take your service also and you must do it this way also. Please don't take it then.
and the rule says that if you don't agree, I can cut
You
off
have,
the service.
they are alternate services. There are alternate, Telegram is an alternate service.
That's right.
You have Botim. You have Botim.
It's said to be more secure.
Supposedly more secure. You have Botim, you have Telegram, you have
Signal.
You have Signal,
You have Signal, Malad.
Viber.
So many of them.
You can take any service. Just like you make a WhatsApp call, Milord. You can make a Botim call.
Mother, the simple thing is if 600 million people are on this service, Mother, has anyone has complained that my sensitive or other information is being misused?
There's a cause of
It's as simple as that. There's no cause of action. This is all in the air in the rules.
No cause of action.
And nobody has ever said. Then why, Mother, if this is what?
90,000 people don't know.
Well, I'm sorry.
Out of these 6 lakh, 5,90,000.
Let's assume that. Let's assume that at least 10,000 people, one would have complained. What is the? Well, there is no data before you on it.
We have been hearing the reverse order actually.
All right, let us
Give
start.
them some time.
You're on to start.
Sometime let us see what they have to do. Why don't we make up our mind whether we should really go ahead or just finish? What do you say?
Yes, I'm very grateful. Thank you. Now, I'll just very broadly indicate what I took away from some of the submissions which were made. The first point I take away is what Mr. Datar stated and what Mr. Sibal and Mr. Rodgi, etc. have elaborated. Their case is, or what they projected is, that there is an extant or existing legal regime. And their endeavor was to project that they are in compliance with that extant legal regime. That takes care of a huge problem or a huge issue which was raised yesterday, namely that all of this is in a vacuum, this is speculative, we have to await the data protection law, etc. If there is a regime, if the government is confident about its regime, that it is adequate, inadequate, there can always be further and future legislative changes. There is no impediment in terms of this court proceeding to hear the matter in the light of the existing legal framework, which includes the statutory framework, which has been pointed out. So there is, according to them, an adequate and robust legal and statutory framework that can, of course, be improved, altered, changed, etc. but your lordships will not be disadvantaged by not having any law to guide you in terms of statute law. So that, I believe, takes care of one set of objections. The second point is a very important point which the court put to us. And here, my lords, I have consulted my colleagues. We will complete arguments on this side by next Wednesday evening, and at the very latest by Thursday. If we fail to complete that, we'll supplement it with written arguments. So next Wednesday evening is our target. At the most, it will go on till next Thursday. They will have the whole of the rest of February to argue, and many weeks if they require that in the month of March to argue. But we will complete and stick and adhere to our time frame of next Wednesday evening, at the most maybe a spillover into the end of next week. That's the second element. There will be more than adequate time to deal with this. The third element which I want to just point out, and here your lordship may take up the orders file passed by this court, or you needn't go to it, because I'll just summarize it. Way back in 2017, and at that time, Mr. Rothgi was Attorney General, and we have the news reports which we have also placed on record. And assurance was extended to the Constitution Bench in April 17 that an act will be passed by Diwali. That was how it was reported in the news items. Our court records it in the order slightly differently. But be that as it may, this issue on this particular subject of introducing a bill, when it will come about, etc., is entirely in the realm of speculation. I think your lordship should not or ought not, having regard to the fact that they say that there is already an existing regime, speculate on what form it will take, when it will pass, etc., particularly since we have been waiting, your lordships, in the month of September 2022, noticed this very bench noticed this. And you had a raft of cases, constitutional bench cases before you. You kept certain matters earlier and sooner, having regard to the Solicitor General's statement that, look, there is likelihood of a bill, etc. A longer date into January was given. And now this matter has been pending for 5.5 years plus before a constitutional bench, and for 6 years before this honorable court when it has come over here. Now, my lords, I just want to step aside a little bit about what this case is about. When you saw the Information Technology Act, and your lordship noticed that section which was pointed out, it was, as you noticed from the 43A marginal note, compensation for failure to protect data. Now, there are two broad elements to this case. The first broad element, which is a very valid element, is data protection. Data protection essentially means that in this electronic age, various persons who are extending service come up with a mass of data. That data is required to be protected by the service provider. And if there is a data breach, there is a visitation of penalty, and there is a detailing in terms of the rules as to what happens if there's a data breach. This is a data breach concept. There's a separate, completely separate concept which comes out from what Mr. Rothgi mentioned and what we have in the documents which we have placed before you, also filed. There is an author whom we have extracted, Shoshana Zuboff, and she describes this as surveillance capitalism. That's her expression, not mine. And I want to spend a few minutes on what is that concept. That is not a concept of data breach, which is being spoken of in the context of 43A and the regulations. That notion is that data in today's world has an enormous commercial value. And that data, which has enormous commercial value, comprises not only what individual data in terms of personal sensitive data, but also a whole notion of metadata. Because as we will see from the material which we have already placed and filed, because your lordships were good enough to request all the AORs to come together and file a convenience compilation, which is also available before the court, that will show the manner in which this particular, even metadata, not the specifics, but the larger issues with regard to when a person, for example, engages in WhatsApp activity, the time zones, etc., that itself has an enormous commercial value. Now, this commercial value is being exploited wrongfully, according to us, by WhatsApp sharing this data with Meta or the Facebook group of companies. On the issue of political speech, they have in December 2022, Meta has entered into a settlement, which we will draw your lordship's attention to very shortly. But in that settlement, in the class action settlement of December 2022, Meta paid out $725 million, because I'm only mentioning this because that was a political speech Cambridge Analytica issue where they had granted third-party access to Facebook users, etc. And there's the whole. So I'm not concerned with that. I'm just giving you an element and a detailed question. Now, what is this nature? What is the nature of the data which they may share? What is the value of this particular commercial data? All of that we seek to explain and project before this court, because this, at the end of the day, is a new policy which they introduced in 2016. So let me just broadly give you, just a few milestones. When WhatsApp introduced their program, the messaging service, they made an assurance to the world at large, please use us. We are not interested in advertising in any manner. We are not going to part with your data to anyone at all. That was the representative. Now, the way capitalism works, and there's nothing wrong with that, is the valuation of this message and the garnering of thousands and thousands of users, as far as WhatsApp is concerned, increase the valuation of WhatsApp, because they had a larger and expanded user base. So they attracted and received more capital. And then they were able to improve the service even greater. Then right through, even in the immediate aftermath of Facebook buying WhatsApp and taking over WhatsApp, the assurance on privacy and the not sharing of data continued to extend. Then all of a sudden in 2016, they suddenly change and alter their policy. So the law as we understand it is that yes, as far as data collected from a service is concerned, there is a purpose limitation. You can certainly use that data, for example, to technically improve the quality of the service which you are giving. And moving forward, we have the advantage of their own practice with this very messaging service to European users. So it's not as if WhatsApp doesn't work in Europe. It works very effectively in Europe. And therefore, what our request is that you furnish an undertaking that, look, just as you did before the European data protection regime kicked in, that we will not share any of the data. WhatsApp's assurance and undertaking to the European regulators that we will not share any of the data with WhatsApp, with Facebook at that point of time. And that is the nature of the assurance we request, because according to us, it's a matter of right in terms of the law which is laid down. Now, with your permission, may I just hand over, just because there were questions which were asked, just what we were hoping that to sort of tempt the court. I've noticed that the court has said that till the lunch interval, your lordship will contemplate this. But this is what I would have handed over, because I thought I was going to start tracking yesterday. So anyway, I have just handed this over, and we'll give copies to the other side as well. It is what we have titled as opening submissions. I'm sorry. Yes.
Into contracts with them. Each user,
yes,
including your client,
right,
would have entered into a contract in the electronic form of it, subject to
Yeah.
agreeing to all this.
Yeah.
Now, if a particular user has actually entered into a contract permitting them,
yes,
to transfer data, rival data,
yes, yes,
Facebook or
yes,
to somebody else,
correct.
then can you come?
So can I just answer that straight away? So let me just answer that in one sentence, and then we'll move on. The standard which according to us ought to be applied, and I had just hinted at that briefly yesterday, is there ought to be first two elements: informed consent when you take the agreement, etc. And second and most important, an opt-out option. An opt-out option that, look, I don't want to give this service. So if someone wants to receive advertisements, by all means, we are not saying that the person should not receive advertisements on Facebook or anywhere else. But if he or she at any point of time, which is exactly what is being done insofar as Europe is concerned, if you have an opt-out option, then no one can complain. I want an option to opt out of this data sharing onwards. So there may be certain elements which they just cannot share because it's visited by penalty and there is a complete embargo. There may be other elements which, as the court correctly puts to me, could be the subject matter of contract. But even that will be within the overarching principles laid down and recognized by this court and applied by this court, not just recognized by this court, and applied by this court on, for example, I'm indicating purpose limitation. Now, obviously, we are going to have to explain all of this as to what it will comprise of and what it will mean, etc. But what is purpose limitation? How far can you go, etc.? Now, I'm answering a question which the court had put a little earlier. Please go. We have tab here. There are a large number of tabs in what I've just handed over. Please go to E. Sorry. Yes, yes.
You were saying that your real complaint is that you are not being permitted to opt out.
Right.
Opt out.
Yeah.
Can you just explain that a little bit?
Of course I can. So what happens is,
we can put it to that side.
Yes, yes. So, Millards, to simplify, because there will be, and I've enumerated those requests, etc. By opt out, what I mean is that an option is given to a user of WhatsApp.
You mean
to the user.
No, you are actually writing for a particular petitioner.
Yes, I'm for two petitioners. They are the two writ petitioners who were there before the High Court and who are now in SLP.
So the relief which you are seeking will be limited to those two petitioners.
I suppose it will be a general policy. So I guess if it's an option to me, I'd be very happy if it's limited. But I suppose there would be, yeah.
Which is a PI.
Internet Freedom Federation to intervene on any of
the same relief.
Same relief.
Okay.
Opt out.
Opt out of the sharing of data.
Yes.
Not from the side.
Follow.
It's a saying, take it or leave it.
So you don't want to leave WhatsApp or Facebook. You want to get the best of both worlds.
Yes.
And you want the data not to be shared.
Actually supported large corporations, cannot take this stand. It is well said in here.
So then what happens to validity of the contract? Are we not indirectly?
These are illegal contracts. Long since held not to be informed.
No, but are we not allowing you to renege on a solemn contract?
No, it's not, Manoj. It's not.
As a public law.
We'll develop that, Manoj. We'll have to develop that. But that is certainly an issue on which we will address and assist the court.
We may have operation for the future. That somebody who wants to newly join WhatsApp, we can perhaps say that. What about you?
We are users who are pre-2016.
Exactly.
And if we are pre-16, we are entitled to continue on the terms and on the basis of the representations which you gave. Because WhatsApp, I mean, this is the argument which we will develop and we will explain it in the context of Indian law, and we will explain it in the context of global human rights law, which is binding on transnational corporations itself, which operate in multiple jurisdictions. So there are strong,
What? You would have also done that. We do it from time to time. They give, what's called revised
terms.
Right. And all of us click in because we need to do that.
Right.
Otherwise, it simply doesn't operate. So when you did that, when your clients did that, would you not have entered into this contract?
So to answer the question, we have not done that.
Right. Where you have agreed for, the transfer
Yes.
data.
So two things I'm just telling you.
Because we keep doing that all the time.
Yes. So
I don't even know how to do it. My son does it for me.
Very well. But I'll just indicate. So in the case of these individual petitioners, they have not opted for that particular, they haven't clicked on it.
You call it update, I think. What is it?
It's an update. There is now there are two categories in India. So there will be one set of people who have opted because, as your lordship said, something comes and you immediately agree, right? For them, again, moving forward, according to us, if we are correct, according to us, they must and are required by law to amend their policy to ensure an opt-out option for the future, even an option. So you may have agreed so far, but you must, that's according to us an element and a basic element and a requirement of privacy, which we will develop and explain.
But
That's one. Second, I'm sorry.
Perhaps they would be doing that under Rule 4.
So,
Time to time.
So, my lords, on the rules, let me just answer you. Just let me indicate the stand of the government of India is on record. And according to them, in fact, we put it in this brief compilation which I've handed over right now, where according to them, WhatsApp is violating. But I'm not into the government of India and their stand on 2011. They have written a letter communication and they've given a tabulated statement. So that the government of India is sort of sure to project its own case. I am now focusing on the concerns because your lordship put to us, what are our broad concerns? Yes. Now that please go to tab E. Tab E. Give it to them. Okay. At tab E, do you have personal data collected by WhatsApp and disclosed to Facebook and the Facebook company? We got that. Your lordship has that heading. So I'm not going to read the whole of it because I realize that we are at a preliminary stage, but just to give you a flavor, please see in red, the personal data highlighted in red font is data that WhatsApp either does not collect or collects at the option of users or claims to keep end-to-end encrypted in certain other jurisdictions. All right. So we have flagged the issues which are red. Then I will get into all these details at a subsequent point. Please go straight away to capital C at page 3. Capital C at internal page 3 of tab E. Yeah. Now this, please allow me to read. How WhatsApp uses this personal data. We've given you the reference in the convenience compilation, etc. Shared with Facebook and Facebook companies. As stated above, WhatsApp shares users' personal data with Facebook and Facebook companies so that they are able to understand how users use their service, to customize and improve their service offerings, and for marketing of their services, irrespective of whether the users have an independent agreement with Facebook or the Facebook companies. This is not limited to making marketing or advertising suggestions, but also includes personalization of content as well as based on user behavior and interaction. The personal data of WhatsApp users is also utilized by Facebook and Facebook companies to show relevant offers and ads across Facebook company products. So here, please, just since an observation was made earlier, there's also political speech because on Facebook, you will get a feed of news articles also based on your metadata, which their algorithms are calculating. So it's not just advertisements. Now, please read on. Yeah. In certain other jurisdictions, WhatsApp assures that any information shared with Facebook and Facebook companies is only used by them in accordance with its instructions and terms. The Facebook and Facebook companies are not permitted to use personal data of WhatsApp users for advertising/marketing purposes or their own commercial benefit. So this is one difference which we have spotted. We will explain that and endeavor to explain that. Now please go to D, capital D at the foot of page 4. Other differences between the 2021 privacy policy offered in India and that offered in certain other jurisdictions. WhatsApp provides a granular and comprehensive list of what personal data is required for exactly what purpose or what function. This is under a section titled Processing Necessary for WhatsApp to Perform its Contract. This disclosure is completely absent from the policy applicable in India. So they disclose, itemize, and I'll take you to the table. They don't do it here. They do it in certain other jurisdictions. WhatsApp allows users of certain other jurisdictions to exercise the right to object to processing of their personal information for direct marketing company purposes and the right to object to processing of their information where WhatsApp claims to be pursuing its legitimate interests or those of a third party. In considering such an objection, WhatsApp will consider several factors such as users' reasonable expectations, the benefits and risks to users, to WhatsApp, to its other users, third parties, and other available means to achieve the same purpose that may be less invasive and do not require a disproportionate effort. 3. The user's objections will be upheld and WhatsApp will cease processing of their information unless it is based on compelling legitimate grounds or is needed for legal reasons. These rights are provided. So these are users' rights. These rights are provided under a section titled How to Exercise Your Rights. This section and right made available to the users is completely absent from the policy applicable in India. 4. In certain other jurisdictions, WhatsApp specifies that information is retained for what period. This is under the section Retention of Information, and this section is completely absent from the policy applicable in India. On the contrary, the FAQ attached to the Indian privacy policy contains entirely vague stipulations, including to the effect that even after a deletion of a user's account, her data may be retained by WhatsApp for an indefinite period. 5. The policy provides for an in-app/web form to contact WhatsApp's data protection officer in the 2021 privacy policy, and only a postal address is given insofar as California is concerned. So there are other details also which we have highlighted over here. I've just given you a flavor in terms of para C1, the last part at the top of para 4, in the context of what we have set out in C1, and also the concerns in terms of B, where there is a huge disparity and a difference in terms of what they do with the data and how they can commercially utilize it. This is broadly going to be the thrust insofar as this case is concerned. Now, as far as WhatsApp and Meta is concerned, if your lordship, I did make a reference, if your lordship is just pleased to go in tab D, your lordship may just go to page 29. Now, this is, your lordship have a list of fines, penalties, settlements of WhatsApp at page 29.
Just before that.
Yes, certainly.
I'll ask you one question.
Yes, of course.
The argument is that actually comparing ourselves.
One of my arguments.
With what is obtaining in Europe.
That's one of my.
Rather than what is being permitted or done in the US.
US. Yeah, all right, very well. In India, well, I'll say in India.
That's right. No. If it is, when you're talking about Article 14.
Yeah.
Classification is reasonable, classification is lawful.
No, I'm not saying 14 applies in this.
So what is your, how do you...
all right. So let me just indicate the constitutional point over here. My constitutional substratum is this. It's broadly in respect of the right to privacy, which your lordships have articulated at great length in the 9-judge bench judgment, which I'm going to place before this court, and also applied those tests in the Aadhaar case, which goes by the same name, Justice Puttaswamy, but the 5-judge bench. So we will place those decisions before the court. Now, elements of privacy are drawn not to one particular article itself, but there is a whole fasciculus of articles, a whole set of articles, and privacy has been held by your lordships while emanating or rooted in several articles to be absolutely necessary to exercise the fundamental rights which have been guaranteed to us. Now, in this backdrop, privacy is anchored in more than one article under the Constitution. Now, what is our submission? Our submission is that as far as the fundamental right to privacy is concerned, there is clearly privacy recognized as a fundamental right via the state. No doubt about that. There are also observations which have been made by this court that privacy, this is in the Puttaswamy judgment, has a certain horizontal element as well, which means that it extends beyond or emanates beyond the state to non-state actors as well. Now, that can happen in a traditional manner, which is that the union government is also here, and therefore an appropriate direction be issued to the union government if it is found wanting to say that, look, the privacy of fundamental rights of citizens is being affected. Therefore, you please take further and appropriate action. That's the conventional way of doing it. That's exactly the manner in which your lordships have extended this jurisdiction, for example, in a whole host of environmental cases, where against private polluters, the case is that you, the Pollution Control Board, or you, the Ministry of Environment and Forests, please do your job better or more intensely, because there is a fundamental right to life. That right is against the state, but it has to be ensured, because there's such a violation or a breach in a hypothetical case by a private player, that it must go there, you must go there and take action. So that is one element of my case. The second element of my case is also founded on transnational human rights law. If you are, as a corporation, recognizing this as a privacy right, then it's our understanding and our submission that the best standard as far as privacy is concerned. Look, it's not our case that every element has to be adopted in India. There may be technical requirements which India requires. There may be technical requirements which other jurisdictions require. That we are not suggesting for a moment that everything which WhatsApp does has to be planted and adopted over here. No. Of course, our laws and laws generally will have a local or territorial reach. But on this element of privacy and on this element of the model in terms of data exploitation, I'll use the expression exploitation, or data usage for commercial gain, etc., the standards are no different according to us, whether you are a European citizen where you are already doing this and us. So my stand is twofold. My respectful submission is that ignore Europe. Europe, which we were putting forward to, was in the context because you're already doing it there. So that becomes easy. You as in WhatsApp, can't raise a technical objection, oh, that this is not possible, that this is too expensive. You're doing it. So that is one part of the problem solved.
Mr. Diwan,
yes, I'm sorry.
Just the European approach.
Yes.
Privacy is absolutism. It cannot
really
be, broadly I'm speaking, cannot be breached. Whereas other jurisdictions like US, it's more of a monetization, that it can be traded.
Yes.
This is the broad difference. So it's essentially a matter of policy in what way.
So, Manoj, may I just answer that point itself?
Yes.
I think a large amount of this.
I may be wrong in my.
No, Manoj, I will. Manoj, it's for others to correct the characterization, but I take it as completely accurate at this point. And I would respectfully submit that is exactly where the option out or the option after an informed consent, that yes, if you tell a user that, look, we will not necessarily use your data and you have an option and you can opt out, which is the European model, and you have a complaints mechanism, etc., where if there's something goes wrong, etc., it can be done. Not a complaint in the context of data breaches. It's very different. A data breach or a data violation where some data is leaked may invite penalties and prosecutorial action because you did not, that's a security issue. I am not on the security issue at all. I am on the commercial exploitation issue. The commercial exploitation issue by WhatsApp, and this will be in a context. The context which we will seek to explain is that, look, these are the stages through which WhatsApp developed and expanded its footprint till 2016. You are bound by those promises qua privacy. You may have other promises, etc. And obviously the world is changing and altering, and there may be certain technical parameters, etc., which may change. But on this element of privacy and on this element of exploitation of metadata and selling it to, or not selling it, but parting with it to Facebook group of companies, according to us, is proscribed as a matter of Indian law. It's proscribed as a matter of the explanations under 21 by our bench under in Puttaswamy, etc. It's proscribed possibly, according to us, also, if your lordships are finally persuaded to accept this, under their obligations as a transnational corporation, it must respect. So, Manoj, I am fully in agreement with what your lordship says. Different jurisdictions may have a different approach to privacy. There may be an absolute approach, there may be a policy issue, etc., and there may be a trade-off. But the option which we are requesting, so informed consent, not take it or leave it. Your lordships heard, they were very plain about what they said. They said, if you want my service, take it. According to us, that's not the law. According to us, an understanding of how this has entirely developed, this how WhatsApp base has developed, their commercial model, representing right through and then suddenly altering it for certain jurisdictions not altering it for other jurisdictions is impermissible. So, my lords, I'm sure there are others who would like to address your lordships before the lunch interval as well. I would respectfully urge that, look, we are ultimately at, of course, there may be some supervening circumstances, but the supervening circumstances normally before a constitution bench, as I understand them in, someone is unwell, etc. Or there is a matter which is of grave urgency, which sort of leapfrogs and has to be taken up early or quickly. If those are the kind of considerations, of course, this case would stand over. But I don't believe, my lords, the prospect that a bill may be introduced and may be debated and should be passed in the facts of this case. Not that I am for a moment suggesting that it's all bona fide. But the Attorney General in 2017 also bona fide had said that, look, we are expecting a bill by Diwali in 2017. So these things, my lords, often take longer. And I would respectfully urge that we are here to assist the court. We would really like to do so on the merits. I'm very grateful.
Yeah. Your item?
I am, my lord, Internet Freedom Federation in the same matter as well.
That's a repetition here.
That is an intervention application announced by, my lord, your lordship in 2017.
Oh, you're in which case?
In the first matter, my lord.
Where
First matter, yeah, in first matter. Karmanya Singh Sareen's matter. There is an order of 27th April 17.
That's right. The same matter with
Same matter, same.
You're supporting him.
We are completely supporting him and supplementing, my lord, the submissions. My lord, the Honorable Justice Bose asked them pointedly, what is it that you are now sharing? They answered about sensitive personal data, but other than sensitive personal data, their own policy, my lord, sets out what they are automatically collecting. Your lordship, just go to volume 10 of the convenience compilation. It's only one paragraph which sets out, my lord, exactly what they collect and what, my lord, they will share with this I agree, which, my lord, they say they have taken from us. What is the legal effect of this I agree? These claims have been pronounced, my lord, predominantly by Lord Denning, though, my lord, about those redlining contracts, my lord, Thornton and other cases. These were cited in the earlier hearing. But just, my lord, we have put it in a chart, my lord, because this is very important, my lord, as to what is it that our immediate concern is in the 2021 policy. Just have this chart. It is in volume 10, page 3687. Volume 10 of the convenience compilation. If your lordships may not have these contracts, may not have not informed consent. It is not with full knowledge of, my lord, what is being sought to be waived.
That can be collectively, so many people have entered this.
Your lordships have given, following your Denning, my lord, Thornton's case, and I'll raise that.
That was in a specific.
My lord, it is very graphically put, my lord, that. But Thornton versus Shoe Lane parking. I'll place them when it comes to that. And following the other case of Sperling versus Bradshaw and others.
There's a Hamlin lecture. Gold judges and Timura's souls.
Lord Atkins, my lord, actually.
They are these cases.
Yes. In fact, Lord Atkins used that phrase, I think, my lord, and
it's in that
Liver City.
51 we All England report.
Yes.
Mr. Viswanathan.
To Donay Stevenson.
Yes.
I just want to express myself.
Yes.
From 10:30 to just switching off to 1. What we are going to examine is whether we should continue or not to continue. Yes, so.
Ultimately,
our request is we have this digital personal data protection bill.
That's correct.
I was just going through this bill. Certain the submissions which Mr. Diwan has made in a modulated form, they have taken note of it. How it will be finally formulated is something will come later, not today. What our request to you is, whatever the submissions are made by Diwan and what you want to supplement him, are these submissions are not being taken care of in this draft bill available to us? Because if you find this draft bill,
I saw the draft bill, I examined.
This term has been changed. Sensitive personal data has been changed to only personal data.
They have said consent, deemed consent,
yes.
all that.
Yes.
Our request will evolve.
Our request is, if you come to this bill of 22,
yes, It is in volume 21, Miller.
Oh, don't go volume 21. Term has been changed.
Yes.
They have made a consolidated, now comes to personal data.
Yes.
In the earlier regime, it was sensitive personal data, the personal data and all things. Now they consolidated and said personal data. And how consent, deemed consent is also defined. Permission with consent, with deemed consent, whatever it is. Now, what our request to you is that we are at the stage when this bill is also maybe introduced, may take 1 time, 2 months time, and in the process. Our request to you is, if the legislature is wisdom, with whatever the complaints are being made in a given point of time and before us, legislature is now taking a call to examine as to whether within my own jurisdiction, I can take those notice of those particular grievances pointed out to us by a common person in reference to reserve the data. How it's to be formulated, how it's to be used, made it available, not made available, to what extent. Our question to it, are we not supposed to wait for the outcome of that bill of 22 and await the legislative wisdom to place before us? And thereafter you find, no, sorry, this particular provision of the act which finally formulated, still our right to privacy is still not being taken care of by the legislature. Examine it. Somewhere, otherwise what will happen?
Respectfully respond.
What will happen?
We have also
Simultaneously, we are going ahead with the legislation on one side and we on the judicial side.
Privacy is a fundamental right.
I agree with you.
And if every
There can't
day
be any compromise.
there is violation, and if you have come to your lordship with an injunctive relief, including an interim injunctive relief, on which notices have gone, are we not
in 17
for this much parity with the solicitor?
In 17, when Mr. Rothgi was, because everybody said Mr. Rothgi was there as Solicitor General, Attorney General. Is this bill like 22 was there?
No, the committee was there. This came, Milord, first in 17 in the draft form. It is noticed, Milord, in the other.
You can see they have gone one step ahead now.
Lordships are not foreclosed from examining, as the learned solicitor said.
Yes.
That he is, Milord, batting for the Indian WhatsApp customers who ought to be put on par, he says, in terms of privacy rights.
That was his first statement.
That was his first statement. Milord. Even yesterday he kept saying that I am not in support of the WhatsApp companies insofar as the breach privacy is concerned. If we can show what data they are collecting, this is metadata, Milord. The message is encrypted. Suppose I say good morning back, that will go in encrypted form. But if it is going from me to my cardiologist and that number is stored as a cardiologist, I will get a pop-up on my WhatsApp. Yes,
It's completely wrong what he is saying. I don't know what he is saying.
Look, this is the intermediaries, they can collect. Kindly see, Milord, what WhatsApp admits in metadata collection. Diagnostic, kindly see that. Just see this, one paragraph. All that we are saying is, give us an option to opt out of that. Till the bill comes, bill is going to say the same thing. I can understand if the bill is going to say something different. Bill is only saying that we are aligning your privacy rights with these regulations. But till the bill comes, just see this.
What the example that you gave.
Yes.
Good morning to my cardiologist.
That was encrypted.
Now, if that is metadata, nothing personal, nothing, this thing is just a greeting.
No, that message will be encrypted. Nobody is complaining of that message which is typed.
Correct. So,
but the groups which go, the status in the group, all that admittedly will not be collect.
That is actually, I mean, it's a commercial element is coming in there.
Mr. Sibal admitted
Use of
that targeted advertising happens because of
That's in the business messaging, not, please understand.
Normal
it doesn't happen. It's a business messaging platform which was introduced in 2018. The trend is completely
You
wrong.
either agree or you don't agree. Just see this, what they admit in their policy. Just see this chart. Does WhatsApp collect? This chart, I'll take it as red. This is what my lord wanted about the data.
I will tell you. 15, eh? Sorry, there is a.